When you're starting a new business, there's just tons of things to spend your money on, and you never seem to have enough as a new entrepreneur. But what do you do first when it comes to legal stuff? Do you incorporate? Do you file a patent application on your new invention? Or do you protect your name with a trademark application? We're going to talk about those three things in this video, and stay to the end because I have an interesting gift that'll be super helpful for you in your new business. Hi, my name is Carr Ferrell. I'm a patent attorney. Welcome back to my channel. When you're starting a new business, the first thing that comes to mind is getting incorporated, that corporate formation. Incorporation can be important because it can shield you as an individual from risk and liability that's created by your business. For example, your business might enter into a contract and fail to perform and create liability. Well, if you're incorporated, if you have a corporate entity, then the risk is on the corporation and not on you individually. And if someone is going to sue you, they would have to sue the corporation and not you personally. But is this really the most important thing? Is it better to protect your invention, to protect your ideas by filing a patent application? Or maybe you spend a lot of money developing a name for your company or a brand identifier for your new product. So which of these things should come first? And as many things with respect to business and the law, there's no clear-cut answer. It really depends on the situation of your business and the stage you are in developing your product. So with respect to incorporation, we have to understand that it's really not an inexpensive process. You have to file documents with the Secretary of State. There's an application fee associated with this filing. It's $100 in the state of California, it's $80 in Delaware, and I think it's $300 in the state of Texas. You'll need to draft an operating agreement. You may want to get help from a lawyer doing that. You may want to issue shares of stock, and many states require that you appoint an agent to accept process in that state, and that can be up to a couple $100. Some states, including California, require you pay a minimum franchise tax. That is a tax for the privilege of operating a corporation in that state, and you have to pay that tax whether you're earning money or not. In the state of California, the minimum franchise tax is currently $800 a year. So overall, it's going to cost you a couple $1,000s to organize your business and to incorporate and pay the fees, especially if you have a professional helping you. And there really are some times when you should consider incorporating early on. For example, if you have other partners in your business, there's multiple of you in your startup, you should consider incorporating, in part just so everybody's on the same page with respect to the organization of the company. If you have employees, you should consider incorporating because there's risks associated with hiring employees. Or maybe others are contributing money to your corporation. In that case, you'll want to have a bank account to deposit the money. You'll need to be incorporated in order to make that happen. And then fourth, perhaps you're engaged in a risky activity. For example, a friend of mine opened a flight school where he was going to teach flying, and he had contract instructors working for him with borrowed airplanes or leased airplanes. And that's a risky business. If there was to be an accident in the airplane, he wanted to have his corporation sued or be liable for the accident and not him personally. So if you're in a risky business, that might be a case where incorporation is important, even as a sole proprietor and even if you have no employees. On the other hand, if none of these apply to you, it may be worth considering just putting off the incorporation for a bit. Save the money and invest the money in other aspects of your startup. Okay, let's talk about patents. Patents can be extremely powerful. They're limited monopolies to exclude others from making, using, or selling your invention up to a period of 20 years. We file patent applications on inventions that are new, useful, and non-obvious, and there's tons of things that can be patented. It can be great protection for a new startup, particularly since we can file a provisional patent application. And if you're short of funds, you can actually prepare and file a provisional patent application yourself. The cost of filing is $75 for a microentity. And patent applications can really help if you're having to work with developers or third parties to help you write software, for instance, or build a prototype. If you're sharing your idea with outside companies, then having a patent application on file can protect your invention from landing in the hands of others. It just makes you sleep better at night knowing that you have the protection of a patent application on file. And it's especially important to think about patent applications when you have co-founders. Co-founders can be complicated because not all of the co-founders may be equally committed, and it can be a real problem if one of the co-founders decides to leave before the company gets formed and the company really gets going. So with respect to co-founders, I think it's important to incorporate the business so you actually have a business entity, and then to file a patent application that covers the technology in the business and assign that patent application or assign the rights in the patent application into the corporation. So in the event that one of the co-founders leaves, the technology remains with the company. You don't have the issue of one of the co-founders leaving and starting a competing company with the same technology. And I'll tell you, that does happen with some frequency, and it can be extremely difficult to get that technology back in the company. So to prevent this from happening, again, form the corporation, file a patent application, have the co-inventors formally assign their rights in the invention into the corporation. So no matter what happens to the co-inventors, the rights to the invention, the rights to the technology stay in the company. Trademarks identify the source of goods and services. They protect the goodwill in the company. An example that everyone's familiar with is Rolex watches. There's a feeling that customers of Rolex get when they purchase and wear a Rolex watch. Rolex wants to protect that goodwill in their brand, and so they do that with trademarks. Now, when starting your company, it's possible to reserve a name. The registration of your trademark can't actually occur until after you advertise your product or service and sell the product or perform the services associated with the mark. So normally it could make sense just to wait on filing the trademark until after your business gets farther along, until your product gets ready to ship. On the other hand, maybe you've spent a lot of money developing your trade name, or you just have a really cool name that you want to get protected before you get started. So these are some things to think about with respect to trademark. So generally, these are some of my thoughts. If you're a sole proprietor, if it's just your business, I would put off the legal expense. I think I would not get incorporated right away. I probably wouldn't spend money on my patent application unless I needed to share my idea with others, and I'd probably wait on the trademark application until I got closer to actually shipping a product. On the other hand, if I had partners, if I had co-founders, then I think incorporation could make sense, especially if we're developing a product or we're registering a name that's valuable to the company. Now, as promised, I have a freebie for you. I have a book that I wrote. It's currently in the 7th edition. It's entitled Monopoly Protection, the 90-Minute Guide to Patents, Trademarks, Copyrights, and Trade Secrets. And there's a link below. If you click the link in the comment section, I'll send you an electronic copy of my book, and hopefully it'll help you in deciding about your patents, trademarks, copyrights. Okay, that's really all I have to say today about incorporations versus patenting and trademark and which comes first. If you have some ideas of your own, put them in the comment section below. I'd love to read them. Thanks so much for joining me on this video. I look forward to seeing you next time.